Gender discrimination. Gender discrimination or sexism is prejudice or discrimination based on a person's sex or gender. It affects both men and women, but it's more apparent toward women. It has been linked to stereotypes and gender roles and may include the belief that one sex or gender is intrinsically superior than the other.
So now we'll be moving on to the facts of the case. The citation of the case is AirAsia Berhad versus Rafizah Shima Binti Muhammad Aris 2014 5 MLJ 318. The parties involved in this case are AirAsia Berhad, the employer, and Rafizah Shima Binti Muhammad Aris, the employee. The suit number of the case is Civil Appeal number B-02275111 of 2012. The case dated 3rd July 2014. The judges that involved in the case are Zahara Ibrahim, Zawawi Saleh, and Umi Khalthum.
Moving on to the issues of the case, the respondent had signed an agreement with the appellant which contained a clause CL 5.1(4), which is forbidding her from getting pregnant during the duration of a 4-year aircraft maintenance engineering training program she was chosen to undergo. The clause provided that if she did get pregnant, it would be a repudiation of the agreement. The appellant terminated both the agreement and her employment when it found the respondent became pregnant during the final year of the course. The appellant obtained judgment for agreed liquidated damages of 92,000 ringgit against the respondent in the session court, but the same was set aside on appeal. The respondent applied on the High Court to declare void CL 5.1(4) for being inter alia.
Hi, now I'm going to be explaining about the decisions that have been made with the case that we have been investigating. In this case, the court rejected both respondents' arguments by ruling that the principle of equality stated under Article 8 of Federal Constitution does not apply in the present case because the constitutional safeguard in the right to equality does not apply to private entities such as the appellant in the present instance. The Court of Appeal was of the view that the High Court judge had erred in law and in fact in disregarding the Federal Court's decision in Biarritz, which was a decision of the Apex Court in Malaysia. In addition, the court also denied the existence of gender bias in the case by holding that CEDAW does not have a force of law in Malaysia in view of the fact that its provision had not been enacted into any local legislation contrary to the views of the High Court in Nur Fadila. Hence, the Court of Appeal concluded that Clause 5.1(4) of the training agreement does not discriminate against the rights of women and does not restrain marriage and or prohibit pregnancy if the respondent completes the training in accordance with the training agreement.
As for the conclusion, Court of Appeal stated that all clauses in the agreement, especially Clause 5 sub 1 sub 4, did not restrain marriage and or prohibited pregnancy if the employee completed the training program in the manner stipulated in the agreement. Therefore, the clauses were not discriminatory in nature. Also in Malaysia, the Federal Constitution was silent as to the primacy of international law or municipal law or vice versa. If there was a conflict, the general rule was that existing municipal law would prevail.